Okay, let's get into it. We're going to unpack a really heavy but incredibly important area of UK family law today.
It's a huge one.
We're diving into the mechanisms that determine a child's whole future, really, when they just can't remain with their birth family. It's a decision that's just fraught with intensity.
It is the definition of a high-stakes choice.
This choice between adoption and long-term fostering.
Absolutely. The legal system is, constantly navigating this fundamental, almost philosophical conflict. How do you ensure a child gets that lifelong security and stability, which is the great promise of adoption,
Right.
while still acknowledging the deep innate value of their original family ties,
Yeah.
especially their connection to siblings? That tension, that dictates the entire legal landscape.
And the material we've gathered for this deep dive, a really critical look at the newest case law from 2024 and 2025, it shows this conflict is getting incredibly heated inside the courtroom.
Oh, absolutely. There is a huge judicial debate happening right now over whether courts should use legal orders, to enforce family contact even after a child is placed permanently.
With a new family.
Exactly. So our mission today is really to give you a shortcut to understanding this current judicial landscape.
Yeah.
We need to clarify how courts decide when adoption is the only path forward and, critically, where they draw the line on mandating contact.
It's a delicate legal tightrope walk.
It is. And understanding where the judges step and where they pull back, that's the real insight here.
So let's start with the basics, because the terminology here is it's everything. When we talk about permanence, we are usually discussing fostering versus adoption. From a legal standpoint, what's the core difference?
The fundamental difference, it all comes down to legal severance.
Severance.
Yes. Fostering, you see, even when we call it long-term, it's still legally,
Yeah.
it's temporary care. The child technically remains the legal responsibility of the local authority. They're the corporate parent. Foster carers are fantastic and dedicated, but they only have delegated authority for the day-to-day decisions. They don't hold the permanent parental rights.
So the birth family tie technically remains, even if the child is removed from their care for a decade or more. That legal relationship is still there, kind of lingering in the background.
Precisely. Adoption, on the other hand, which is governed by the Adoption and Children Act 2002, the ACA 2002, is completely different. An adoption order legally and permanently severs that relationship.
For good.
For good. All parental rights and responsibilities transfer entirely and for life to the adoptive parents. It's the only path that offers that child full, lifelong security and legal certainty.
But what if a child is in a long-term fostering placement, and they're happy, they're stable, they've been there for years? What's the psychological difference for them? Does the law just say it's temporary, even if the child feels like it's permanent?
And that's where the law steps in and says the child's feeling isn't enough. The legal framework of fostering is still, precarious.
Precarious how?
A foster placement can end. The child could be moved, or the birth-parent relationship could be reignited in a way that disrupts the child's stability. It's that lack of legal security that ultimately leads the courts to find that fostering doesn't meet a child's lifelong welfare needs,
Yeah.
especially for very young children.
That makes perfect sense. And before we move on, we should probably touch on some of the types of adoption being used now. I'm thinking of things like fostering to adopt.
Yes, fostering to adopt is designed for early stability. The child is placed immediately with approved adopters who are also approved foster carers. If the court then grants the placement order, they adopt the child. It prevents multiple moves in those really crucial early years.
And there's also overseas adoption.
Right, which has very strict criteria. The most important being you have to prove the child can't be safely cared for in their own country.
And the hurdle for any adoption is incredibly high. I mean, beyond the basics, applicants being over 21, the child under 18, the real test is necessity, isn't it?
It is. You need the birth parent's consent, unless the court is satisfied that dispensing with that consent is required because the child's welfare demands it. And that is where we jump into the core judicial conflict.
And that conflict is framed by this standard the courts apply. Adoption is seen as an extremely radical or very extreme intervention. It can only be a final measure.
That's the classic phrase the judges use, drawing from established legal authority. It must be a last resort. The language they use is, nothing else will do.
Nothing else will do.
It sets an almost impossibly high bar because, adoption is the most radical interference with family life imaginable under human rights law. The court has to show it's necessary and proportionate.
But if nothing else will do, Long-term foster care, or LTFC, often presents itself as that something else that might do. Yet we're seeing judges get more and more critical of it.
That's a crucial insight. In cases like re-LRP, we saw a really powerful critique from Puffley J. She called LTFC a precarious legal framework that just inherently lacks security. It doesn't provide that enduring sense of belonging a child needs.
So even a really devoted foster care placement, it's still legally vulnerable. This brings us to a major 2024 Court of Appeal case, DS, a child, adoption or fostering. What does that one tell us?
This case is a fantastic illustration. It involved an 11-month-old, C. The initial trial judge refused a placement order favoring LTFC,
Why?
primarily because C had two older half-siblings who were staying in foster care. The judge wanted C to keep maximizing that sibling bond through fostering.
So the judge prioritized the existing family link over legal permanence, but the Court of Appeal.
Came down hard on that decision. They overturned it entirely. Lord Justice Peter Jackson said that for a child this young who needed to form a foundational primary attachment, the need for a lifelong family was overwhelming.
Overwhelming.
Yes. The Court of Appeal rejected the LTFC option because of its manifest disadvantages and insecurity, even while recognizing how important those sibling bonds were.
It sounds like the principle is, when the child is very young, the need for security just trumps nearly everything else.
Exactly. And adoption provides that security, which LTFC simply cannot. That's confirmed in other judgments too, like BCP Counsel VM. Even with devoted carers, the legal instability of fostering is often the deciding factor.
Which brings us directly to the most complex part of all this. Siblings. If adoption legally severs ties, how can courts maintain that crucial bond between siblings who aren't being adopted together?
This is where the tension becomes acute. And it's where the courts try to engineer a compromise. The mechanism they use is what we call the contact mandate, the power to make a direct contact order under Section 26 of the ACA 2002.
Section 26.
It allows the court to set a blueprint for future contact even while a child is waiting for an adoption placement. It's the battleground where permanence meets identity.
And we have two huge appellate cases from 2024 and 2025 that show the judiciary really wrestling with this. Let's look first at the case that successfully used the mandate. RNC, adoption or fostering.
Right. In REOR, the local authority was trying to get a placement order, but the trial judge refused it. The judge was concerned that adoption was just fundamentally inconsistent with the younger children's confirmed welfare need for continuing contact with their older siblings.
So the judge basically said adoption is too disruptive to this sibling group.
Pretty much. So the local authority appealed, arguing that they could find adopters who would be willing to facilitate that contact.
And the Court of Appeal agreed.
They did. And this was a critical moment for the whole concept of open adoption. They allowed the appeal, but they used their power under Section 26 to mandate the local authority to search exclusively for adopters committed to a high level of direct sibling contact 6 times per year.
Wow, that is a firm instruction. It didn't just suggest contact, it made it a non-negotiable term of the search.
It effectively set the template for contact moving forward. The message was clear. The need for sibling contact doesn't automatically rule out adoption. Instead, the adoption has to accommodate the contact.
Okay, that sets a clear precedent for mandating contact. Now let's look at the counterpoint. Ray S., placement order contact, where the court refused to do that even though everyone agreed contact was desirable.
Right. This involved S, who was 2, and R, who was 8. R was planned for long-term fostering, S for adoption. Everyone agreed that continuing direct sibling contact was highly desirable for 2-year-old S's welfare. Yet the court ultimately refused to issue the Section 26 order requiring it.
Wait, if everyone thought it was desirable, why pull back? What was the deal breaker?
This is where the legal system hits practical reality. The trial judge accepted compelling professional evidence that a mandatory legally binding order risked acting as a deterrent to potential adopters. And this was particularly sensitive because S had an uncertain neurological prognosis after an injury, which meant the pool of potential carers was already smaller.
So the court decided that the need for a placement, any placement, was the absolute welfare imperative, and they weren't willing to risk limiting that pool of adopters by imposing a legal contact requirement.
Precisely. They relied heavily on a legal idea known as the Section 16 no order principle,
Which says?
that the court shouldn't make an order unless doing so would be better for the child than not doing so. In a retest, the judge reasoned that making the order would create this massive practical risk of deterring adopters. Therefore, refusing the order was actually better because it protected the primary goal, finding a permanent home.
That raises a really important philosophical question, though. In retest, the court is essentially saying the preference of an unknown future adopter is more important than the confirmed desirable need for sibling contact today. Isn't it prioritizing recruitment logistics over the child's established welfare needs?
It creates a massive conflict, yes. The tension is palpable. The judiciary has a duty to set the contact template, like they did in REAR. But that duty is constantly balanced against the legitimate concern that a mandatory order could compromise the greater priority of finding an adoptive family, especially when a child has complex needs.
So the stability of a home, even one without mandated contact, is seen as the foundation.
It's seen as the foundation upon which all other welfare concerns must rest.
Given that REAR mandated 6 times a year contact, did that suddenly become the standard that everyone was supposed to follow?
Absolutely not. And the Court of Appeal in REA issued a specific warning about that. They said lower courts should not blindly impose the 6 times a year rate from REAR.
It has to be bespoke.
It must be bespoke, reflecting the unique needs and risks of that specific child and that specific placement. It can't just be copied and pasted from a landmark judgment.
And if we connect this back to the bigger system, it sounds like the whole thing is just stretched and highly complex, leading to these case-by-case crises. So it's no surprise that the Public Law Working Group report from November 2024 called for wholesale reform.
The complexity is certainly breeding these legal battles. The PLWG report outlined key areas needing change across the board, from better training for birth parents on contact to creating a national protocol for accessing adoption records. Critically, they called for simplifying the often Byzantine system for international adoptions.
And speaking of international adoption, the complexity of imposing mandatory contact must be exponential when the adoptive family lives abroad.
It creates huge problems with enforceability. We saw this in a 2023 case, Mrs. H and MSA. It involved an inter-country adoption of a child to a solo adopter in Canada. The birth mother requested mandatory video contact.
And the court refused. Why? Beyond the difficulty of enforcing an order in Canada.
Well, there were high risk factors in that family, including a history of abuse via media. But the principle was paramount. The court accepted that imposing mandatory contact on an unwilling or reluctant adoptive parent is generally not appropriate. It risks undermining the whole placement.
And it's almost impossible to enforce overseas.
Exactly. In that case, the court approved letterbox contact. Exchanging updates through an intermediary but direct contact was refused. The primary goal was securing that safe placement in Canada.
So what does this all mean for you, our listener? The essential takeaway seems to be that the goal of modern placements is shifting toward open adoption, recognizing the value of family contact for a child's identity.
That is the aspiration. The legal landscape is evolving to recognize that fundamental need for a child to retain ties to their identity and heritage. But this aspiration is constantly checked by the practical legal reality of that nothing else will do test.
Permanence is still the trump card.
Permanence in the form of a stable adoptive home remains the legal trump card. If the need for contact threatens that security, security wins.
And a recent case law confirms that contact has to be bespoke. And while courts are more willing to use Section 26 to force local authorities to search for contact-friendly adopters,
They will not make that order if the professional evidence suggests it threatens the primary goal of securing permanence for a child, especially a child with greater or more complex needs. The balance is truly, truly delicate.
which leaves us with something provocative for you to mull over. We've seen that ongoing sibling contact is nearly always desirable for an adopted child's lifelong sense of identity. If the risk of deterring potential adopters, so the preference of an unknown future carer, is the determining factor in refusing a Section 26 order, does that mean the legal system is subtly prioritizing recruitment logistics over the child's clearly articulated lifelong identity needs? Is the law inadvertently rewarding adopter reluctance? That seems like a massive philosophical weight hanging over the ongoing legal reform in the UK.